Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Brandy Thompson from the Kronzek firm, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law. Today we'll be talking about the Derek Chauvin criminal trial, custody cases, and the controversial no-fault auto reform. Stay tuned.
In the name of personal injury law.
The no-fault reforms of 2019 have been controversial. While some support these reforms, many others have concerns about the fairness of the reforms and the impact on the medical care rights of those injured in auto accidents. Some of the most concerning aspects of the reforms have just taken effect or are about to take effect this July. We have Steve Sinas and his law partner, Katie Tucker from Sinas Dramis Law Firm to talk with us about these changes. It's great to have both of you here.
Thank you. It's great to be with you, Lisa.
Thanks so much. It's great to be here.
So we're going to talk about your concerns about the three different ways the 2019 reforms may impact the rights of patients under the no-fault system. My first question is whether these changes are going to apply only to those injured in accidents now, or do those changes apply to even those people who were injured in accidents before the law changed?
So we're going to talk about three issues here today. The first issue is how the law drastically reduces payments to medical providers. We're also going to talk about how the law drastically limits the rights of people to receive in-home care from their family members and friends. And we're also going to talk about how the law creates new complicated ways that the government can regulate medical care rendered to those injured in auto accidents. So those are concerning changes to us, and we're going to explain that in this episode here today. But let me first start by answering your question. And the answer to your question is these rules are intended to apply to everybody in the system. And we think this is an unfair aspect of these laws because the people who were claiming benefits under the old law bought an insurance policy from their insurance company that was based on the old rules. And now the legislature comes in and changes the rules, and the law says it's supposed to apply to everybody. And our firm is pursuing a lawsuit over this issue where we're seeking a ruling from Michigan appellate courts that such a law is unconstitutional because it infringes upon the contractual rights of consumers in terms of the policy they bought and their rights under that policy. So all these rules that we're going to summarize here today are intended to apply to everybody. And that seems to us, at least, to be a great element of unfairness.
So what about the payment reduction to the medical providers who treat those people injured in auto accidents?
Yes, Lisa, as Steve mentioned, one important way that the reforms will adversely and unfairly impact auto accident victims is that the new law drastically reduces reimbursement to their medical providers. Under the old law, a medical provider was entitled to reimbursement for all of its reasonable charges for treatment rendered to individuals injured in auto accidents. Now, under the amended law, starting July 1st, 2021, just a few months from now, a provider's reimbursement will be significantly reduced from current levels and subject to new statutory caps. In fact, for many providers, reimbursement will be capped at 55% of what they charged under the old law. This drastic 45% cut in reimbursement will effectively force many providers to limit the number of auto accident victims that they treat or to stop providing treatment altogether, thereby restricting access to care to many injured persons across our state.
Okay. Does the 2019 reform limit the rights of injured people to receive in-home care from family members or friends? And if so, how does that law do that?
So when somebody is severely or catastrophically injured in an auto accident, they have their hospital care and they're released from the hospital and they go home and they need in-home care. And under the original law, these people were able to form agreements with their family members and their friends to come over and provide them the care they needed. That was a level of comfort to them because they knew these people cared about them, and these people could go about providing this care by being paid by the insurance company. So if they had to take time off of work and rearrange their lives to provide the care, these people could be paid. The new law says that if somebody is your family member, your roommate, or your friend, they are limited to 56 hours of payment for care rendered each week. They cannot be paid for anything more than 56 hours. So if somebody needs 24 hours of care, what it comes down to on average, they can only have their family members or friends be paid to render 8 of those hours. They then have to turn to the outside world, to strangers, to commercial care to get the extra 16. We wondered why was this the case? Why did the legislature choose to limit the people who could actually provide care for people? And it's befuddling to us, it's concerning to us, and it's certainly going to be something that those who have been used to their family members and friends providing care are going to be in for a rude awakening when they find out that they no longer can be paid and they have to start getting care from strangers. So we also are concerned about this aspect of the law.
Well, Steve, I'd like to follow up with your comment. Isn't it actually going to cost the insurance companies more money by having to add the 16 hours of out-home care by some professional to make up the difference for those people who actually do need 24-hour-a-day care? It
could. Now, the insurance companies can try to agree to pay more than 56 hours to family members or friends, but it gives them all the leverage. This is an anti-consumer type of provision as far as we're concerned. When it comes down to it, people should have the right to choose who their care providers are. They shouldn't be told by their insurance company who their care providers should be.
And that's particularly true when the people are coming into their home with their family, right, Steve?
That's right.
Okay. And then how did the 2019 reform increase the power of government to regulate and potentially interfere with the medical care of people injured in auto accidents?
Thank you for that question, Lisa. As Steve mentioned earlier, again, the reforms will lead to increased governmental regulation and interference in auto accident victims' ability to access medical care through a process known as utilization review. Under the old law, decisions about the type and amount of medical care and medical treatment that an auto accident victim needed were left in the very capable hands of their doctors or other providers. When disputes arose, a patient could challenge an insurer's denial of treatment by filing a lawsuit in a Michigan trial court. Now, under the amended law, decisions about the type and amount of treatment that the auto accident victims need and receive may actually be made by a governmental agency, the Department of Insurance and Financial Services, through the new utilization review process. Importantly, patients have absolutely no role in this process. And although patients can still file a lawsuit to recover unpaid benefits, decisions may be made before they can do so and without their involvement. The only entities involved in the utilization review process are insurers, medical providers, and the Michigan Catastrophic Claims Association. The process is governed by a set of rules developed by DIFS, the Department of Insurance and Financial Services, that are cumbersome and extremely complicated. To learn more about the rules and the process, please check out our utilization review page on autonofaultlaw.com. And just following up on a point Steve made earlier, Lisa, all of this just goes to show how unfair this new law is, especially for those injured in auto accidents well before the law took effect on June 11, 2019. As someone who might be injured in an auto accident today, those who were injured before the new law took effect their claims will be subject to this utilization review process. And so for many of these people, for decades, they were receiving and able to access care without governmental interference, without governmental regulation. And now they are going to be subject to this new UR process, these new rules, and this additional layer of administrative bureaucracy when they're trying to access care that they desperately need.
So just because we've shared a lot of information today, Steve, could you just give us a quick recap of what parts of the law have already gone into effect and then what's coming just around the corner?
Right. So let's not lose the forest for the trees here. One of the major features of this law is it took away the lifetime right to medical care through the no-fault system for many people. This includes even children whose parents buy a less than lifetime policy. It includes a lot of people who would normally have received lifetime care, and under the reforms, they're going to be capped and only have so much money available for their medical care. And what we're talking about here are all the other ways in which this law takes away the rights of patients and limits them in terms of how they can get their services paid through insurance. And these are the concerning matters that we wanted to bring to the viewers' attention today.
Thank you both, Steve and Katie. And can you tell us that website again?
Yes, Lisa, it's autonofaultlaw.com. We encourage you to check it out.
Thank you so much. Have a great day.
Thanks. You.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm. in the name of criminal defense.
A jury returned a verdict on the Derek Chauvin criminal trial, and they found him guilty on all counts, including on murder. Mary Chartier and Takura Nyamfukudza are longtime criminal defense attorneys. I'd like to hear what you have to say about the verdict and what you thought it would be.
Well, most people, based on the reaction, were happy. I knew there was a chance. I thought he might be found guilty, but of course, there's always a chance that somebody may be acquitted. And all it takes is to convince one juror and you could have a hung jury. But, we've had trials go both ways. So that is what I thought the verdict would be, but I would not have been surprised if it had turned out differently.
Were you more surprised that he was found guilty on all counts instead of just on maybe one lesser count?
Yes.
Yeah. So how did this trial compare to other trials, or how was it similar to other trials?
One of the things that was really interesting about this trial is you had this, the biases that we frequently see in criminal defense cases flipped, or at least at odds. So frequently the jurors are pro-prosecution, pro-police. They're more likely to acquit a Caucasian when it is an African-American victim, and they're more likely to convict an African-American defendant, especially when there's a Caucasian victim. Here you had those biases at odds. And so that's why even when you have this almost 9.5-minute video of a police officer murdering a man, that's why you still have, people thinking, well, is he going to get convicted? Because will the bias of the jurors be so strong in favor of the police that they just wouldn't convict him? That what was really interesting was you had so many police officers testifying that Derek Chauvin's conduct did not reflect proper policing at all, and that it was unreasonable and didn't follow protocol. I think that probably tipped things quite a bit in favor of the prosecution.
And were those officers that testified part of the same police department as Mr. Chauvin?
Some of them were. Some of them, it was the supervisor, training people, a number of them. So it's not just expert witnesses who are being paid, or in some cases, in this case, they did it for free, coming in and testifying. It was some people from his own department.
Wow.
Including the chief.
Right.
So Mary and Takura, you have worked on a lot of really high profile cases. So let's talk a little bit about the media coverage in this case and how that impacts the conduct of the trial.
Well, there was a lot of it, day in, day out, and nobody really had anything good to say about the defense. And it was, the case had already been tried essentially in the court of public opinion. And it was just very negative. Again, and I don't mean to suggest that we've ever defended anyone who people in the public were generally championing, but the nature of the cover, I think, and harkening back also to all the protests that began immediately after Mr. Floyd was killed, there was kind of a message that was being sent to the jurors, which I think they understood. And I don't know, of course, I wasn't in the room as they were deliberating, but I think they had that at the forefront of their minds about what would happen if they had decided differently.
So let's talk about the jury. Mary, did you want to say something?
I did, right? So what you see is essentially media coverage on steroids in this situation, as Takura said. There's nothing that even, Eric Nelson, who defended Derek Chauvin, did do some interesting things in defending him. Obviously they weren't effective, but when you have a 9.5-minute video of your client murdering someone, and some of it was extremely damaging, when he's picking gravel out of the tire while, Mr. Floyd is like begging for his life and saying he can't breathe. I mean, that's unbelievably callous conduct. And so, whether there was media coverage or no media coverage, I think in this situation, an unbiased jury would have reached the same verdict. But he did poke some holes in the prosecution's case. The prosecution did make some missteps in terms of evidentiary issues. They withheld and didn't seek the carbon monoxide evidence, and then tried to get it in. I mean, that was really bad faith on the part of the prosecution. Very little of that was covered by the media. And the bias for the prosecution people see it, and it happens all the time. When people are charged with a crime, it really in the media, it's like they've been convicted already.
Sometimes even before charges are issued.
Definitely.
So talking about this jury and the wait for the jury verdict, which I think the whole country was collectively holding our breaths while we're waiting for the jury verdict. Was this an unusual wait, or can you tell us about the process of the jury deliberations?
Well, Takura's had, I think, 7 minutes is the
7.
fastest you've had. Mine was
7.
13. I think the longest has been 3 days for both of us where they've been out. That's an incredibly long wait. This, when it came back as quick as it did, I thought it would be guilty, at least on some of the counts. The wait for, I can just tell you as a defense lawyer with your client, is terrible. I mean, it is, you can't think or do really anything else other than think about that verdict coming in. You replay everything in your mind. You think about an objection you should have made or a question you should have asked, or it's just, I mean, your stomach is flip-flops. You can't keep a thought in your head. Someone said that, Mr. Floyd's brother was pacing inside waiting for the verdict. But, I feel you, because you just really can't even sit still.
Well, and the verdict didn't come back the same day, right? It was the day after the closing argument. So,
but they closed pretty late. I mean, they closed really late in the day, so it would have been almost impossible for them to reach a verdict that day.
And the jury wasn't able to leave at that point, isn't that correct?
Correct. Yeah, they were sequestered.
Yep.
Well, so here's the big question: is this justice?
Well, I think George Floyd's family believes so, but again, let's see what happens at sentencing. And I'd like to make a point. Every single day during that trial, somebody was killed by the police. And even on the day that the verdict came back, right? Somebody got shot. And a young woman in Columbus, Ohio, I think, got shot by the police. So I don't think it just ends at the verdict. There needs to be an overhaul of the entire system, policing everywhere. So every single day of that trial, somebody was killed by a police officer.
It's accountability. I don't think it's justice. I don't see, George Floyd doesn't come back to life. So, it's maybe justice in some form, but it's more likely accountability. Will there be true reform? That's going to be significant. I don't think he has any shot on appeal, quite frankly. So, I think, as Takura said, the real test will be sentencing. But what I think people should note is, no matter what his sentence is, there are people serving far longer sentences for drug crimes where there's been no violence, no death. So, again, it really highlights the need for reform. We talk about all these cases on our podcast, Constitutional Defenders. Lisa, we could talk about this for hours, more and more and more. It's a very interesting trial and a very interesting time.
Well, thank you for sharing today. We appreciate it.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Family Law.
Today I have with me Chuck Kronzek of the Kronzek Law Firm. He is a partner and founder of the firm and has been practicing family law for 26 years. And we are going to talk today about custody cases. Welcome, Chuck.
Good morning to you.
So let's give our audience a little bit of an understanding of how custody cases work, and I'll let you take the lead on that.
Sure. Custody is probably the most common question that we get from both clients and prospective clients, just because it cuts so close to the bone. I mean, there's little that's more important to people than custody of their children. Most judges agree that there aren't more difficult decisions that they have to make, or very often, than custody decisions. So it's important, it's very difficult, both on the judges, on the attorneys, and the parents as well.
Well, let's talk a little bit about when a couple is getting divorced, like making, how does it work in having a custody decision at that point of the case?
Yeah, early on when a case is filed, the first road that it goes down is the friend of the court road, and cases are often referred in most counties to the friend of the court for an initial workup and recommendation. Those go by various names, but whatever the name is, it's an initial meeting with the friend of the court. Usually both parents are there. Occasionally attorneys are there, and they're done together, except in cases of domestic violence, and then they're done separately. But the friend of the court is looking for some key markers, and most of the workers at the front of the court office are very experienced in sorting through the facts. One of the things that they look for early on is to figure out what the parents have been doing for a long time. That is to say, if mom is a full-time out-of-home worker and dad is a stay-at-home dad, or vice versa, or maybe they split the parenting responsibilities, the friend of the court will want to know that early on. From there, the friend of the court's going to want to know whether the parents have an agreement or what each parent's asking for.
And just so the audience understands, the reason we have the friend of the court, or a large part of it, is to help the parties come to an agreement, right? So that the case doesn't have to go before a judge. They're trying to resolve as many cases as possible without litigation, which is obviously time-consuming, expensive, and stressful. And in my understanding is that the friend of the court process does indeed resolve a good number of cases.
They do. In fact, that's really why they exist, or existed back in the day when they were created, was to take a lot of the heavy lifting, or the initial heavy lifting, away from the judges and put it into a system that could process these very disputed cases rather quickly. They get involved early because the last thing that we want to see happen is a tug of war with kids in the middle.
So when we're talking about a couple that's divorcing and now they're living in separate households, is the first thing that the friend of court does is help come up with what's called an interim order, or something to get the parties some sort of parenting time established while we're waiting for the final decision?
Yeah, that's their most important early job, is to avoid the tug of war and get a temporary order in place. So the friend of the court will gather information that they need, put together a recommendation. If there's not an agreement of the parties, there will be a recommendation. The recommendation will go over to the judge. The judges seldom read those recommendations. They kind of rubber stamp them, and that's how we get an initial custody order. It's a temporary order, and it's subject to objection and change, but nonetheless, it's got to be followed until the judge says something different.
So you brought up an interesting point about the tug of war. So let's talk about where there is a tug of war and one of the parties, sometimes even both of the parties, don't agree with what the friend of court is recommending. What happens then? Yeah,
so there are objections to file, but again, you've got to obey the temporary order until the judge says otherwise. So your attorney will file the objections, and they follow a specific format and contain specific information. Once that happens, in most counties, the case will get referred to a referee, an attorney referee at the friend of the court office. There are some counties that don't do that. Sometimes they send them right to the judge, but mostly here in mid-Michigan, they're going to go to a friend of the court referee, where you will have your very first evidentiary hearing. That is to say, you will have the opportunity to present evidence, witnesses, and other things that your attorney will determine will assist in proving your case and getting to a different custody decision if that's what you want.
And so speaking of the friend of court and going through the referee process, I think what that referee has to do is very similar to what the judge does if the hearing were going to be in front of the judge, as far as going through all the legal steps. So can you talk a little bit about the process of deciding a custody case, whether it's a referee or a judge?
Yeah. So the whole process is at the front of the court is a mini trial, if you will, but they follow the same sort of a process. And again, they're going to want to know what's been going on over the years with this child or the children, who has been doing what. They care about that because one of the purposes of our Child Custody Act is to ensure consistency for minor children. So we presume that lack of change is a good thing for kids. So the friend of the court, the judge, everybody involved will figure out what's been going on. The next step along the way is that the court has to decide what's in the child's best interest. And our courts and our statute have set forth a list of factors. And so the referee or the judge is going to be required to analyze each of those 12 factors and make specific findings of fact and conclusions of law on each of the 12 factors. They have to be in the record. And when I say in the record, they've got to be a part of an opinion. So each of those 12 factors gets weighed. The factors do not have to be weighed equally. And in fact, our appellate courts have allowed an examination of the child custody factors where one parent has prevailed on 11 of the 12 factors and the other parent only one. And the courts have allowed custody to go to the parent that prevailed on only one of the factors because they don't need to be weighed equally. So
Right.
There's an examination of those factors, and that's how the determination begins.
And then we have some problems that, parents should be aware of when they're going through a divorce or getting their initial custody order. Can you share some things that, problems that arise in these cases?
Are we talking about during the pendency of the case?
Yes. Mm-hmm.
Yeah. Well, there's always problems in the pendency of the case. But again, the very first thing, the worst thing that we see is the tug of war. Sometimes we see parents trying to make significant changes in a child's life, whether it's somebody up wants to grab the child and run to a different county or sometimes a different state. And sometimes we have an international case where they want to go to a different country. We also see difficulties sometimes during parenting time exchanges. Sometimes we see difficulties popping up when social media gets involved. That's common these days. Sometimes we get parents that decide to badmouth the other parent. And
In front of the child is not looked on very kindly by judges.
No judge that I know of will tolerate bad-mouthing another parent, more particularly if it's done with the intent to alienate a child and a parent. That's just horrific. Yes. So those are just some of the problems that we see. And sometimes when we see them all, or we think we've seen them all, something new pops up.
You're right, Chuck. Thank you so much.
In the Name of CPS Defense and Family Law is brought to you by the Kronzek firm.
Thank you for watching In the Name of the Law. We look forward to seeing you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.